Good afternoon. This is Heidi Myers, and today we're going to talk about some national interest exceptions to the recent travel ban. The Presidential Proclamation 10,014 banned L-1As, L-1Bs, H-1B temporary professionals, H-2B temporary and seasonal workers, and certain categories of J-1s. The J-1s that were banned include au pairs, teachers, J-1 interns and trainees, and summer camp counselors. Additionally, this banned anyone outside of the United States on the effective date of the Act, June 24th, 2020, and who did not already have a valid visa. So those employers who had filed H-1B petitions back in April for employees to come to the United States as professionals, say software engineers or IT architect managers, if the employee sponsored did not already have a valid visa by June 24th, 2020, which was extremely unlikely since the H-1Bs can take a while to process, it can take a while to get an approval, and plus all the US consulates and embassies had been closed for several months. So it was very unlikely that any employer who filed an H-1B this spring for a start date of October 1st, 2020, it's very unlikely that the employee, the sponsored employee, would already have a valid visa. So those employers who already filed H-1B petitions, or say you already filed an L-1A petition for a multinational manager or executive, even if you already have an approved USCIS petition, your employee is not going to be able to get a visa until 2021. Basically, the ban is effective if you did not already have a valid visa by June 24th, 2020. Now, there are exceptions to the ban. They're called national interest exceptions. The first exception is for L-1s, that includes managerial, executive, and managers. L-1B, specialized knowledge workers who are transferees from abroad, as well as H-1Bs. This exception includes healthcare workers, healthcare professionals, and medical researchers. So healthcare professionals and medical researchers whose work relates to COVID-19, say a doctor or nurse taking care of COVID-19 patients, or a medical researcher researching vaccines for COVID-19, those are accepted under the national interest exception. Additionally, medical researchers can be accepted if they're working in an area of public health significance, such as cancer or communicable disease research. There is another exception for H-1Bs, temporary professionals, and H-2Bs, seasonal or temporary workers, if their work is pursuant to a U.S. government agency request. So it can be the U.S. government or a U.S. government agency or entity that requests that the H-1B or H-2B come to the United States. This is generally for employers who have contracts with the federal government or with a federal government agency. The State Department gave the example of an H-1B or an H-2B who's coming to the U.S. to work on a construction project or an IT infrastructure project on a U.S. Army base, or another H-1B who's coming to the United States, say a software engineer, to provide IT services for a U.S. government agency. They frame the language so it's not just includes contracts, but it also includes if it fulfills U.S. foreign policy objectives. Okay. So aside from that, regarding the J-1s, it's important to keep in mind not all J-1 visas are banned. So for example, J-1 research scholars and professors are not banned. Thus, if you are a J-1 research scholar or professor, you do not need to qualify for an exception. The same is true for international medical grads, J-1s who are coming to the United States to work in a US hospital residency program. They do not need to qualify for an exception. They don't need to show they'll be working on COVID-19 patients. It can be any type of hospital residency. Then regarding J-1s, there are certain exceptions for au pairs, where the au pair has specialized skills or certifications to take care of a child with specialized needs. So the child does not have to be a US citizen as long as the child is in legal status here in the United States. So both the child has to be diagnosed with special needs and the au pair has to have certain specialized skills, training, education to show they can meet those needs. Another exception would be where the au pair is coming to the US to take care of an individual, and you can show that if not for the care of the au pair, the individual would become a public charge or a ward of the state. Another exception is where the au pair is taking care of the child of a medical professional who's assisting COVID-19 patients. Additional exceptions are for J-1 interns or trainees who are coming to work at the request of a U.S. government agency on a program that would aid in the economic recovery of the United States. Yes, so anyway, there are a few other exceptions. It's important to keep in mind that not all work-based categories are banned. So as we already discussed, for the J-1 research scholars and professors are not banned. J-1 international medical grads are not banned. Additionally, under the presidential proclamation, E-1 treaty traders, E-2 treaty investors, H-1B1 for Chile and Singapore are not banned. The O-1A for aliens of extraordinary ability in the science, education, athletics, or business are not banned. O-1Bs for aliens of extraordinary ability in the arts, which is very broadly defined, are not banned. P1s and P3s for athletes and artists are not banned, as well as certain categories. For example, the Australian E3 is not subject to a ban. However, as a practical matter, you have to keep in mind that the US Embassies and Consulates had most of their staff, most of their personnel recalled back to the United States in March. So there are very few personnel still at the US Embassies and Consulates overseas to process either your request for a visa or your request for a national interest exemption, because there's just so few people working at the US Embassies and Consulates. Good luck trying to get their attention. It will be very difficult. So as discussed, the ban lasts until December 31st, 2020. So any employee subject to the ban will not be able to obtain a US visa or come to the United States prior to January 1st, 2021. So like I said, all those employers who have pending or approved H-1Bs, so they have an approved H-1B petition approved by USCIS, or they might have an approved L-1A as a managerial or executive transferee. If the employee did not already have a valid visa on that date, June 24th, 2020, they're not going to be able to apply for a visa, and they're not going to be able to enter the United States until 2021. All right, so that's all for today, folks. And if you have any questions, please don't hesitate to ask. I'm happy to take any sort of suggestions for a new video. And please like my video and subscribe to my channel. Thank you so much, and everyone have a great day.